At the Free Speech Center, we celebrate the 5 freedoms of the First Amendment. And those 5 freedoms are contained in a document from 1791 that you all know as the Bill of Rights. Yet 2 years before that, we had constitutional ratification occur in 1789. And that gave us the document that has driven our nation ever since. What's interesting about those 2 dates is that in 1791, we got the freedom to write whatever we want, to say whatever we want, create whatever we want. But 2 years earlier, the first generation of Americans had the wisdom to include in the Constitution a guarantee that we could copyright our work. Now, why is that important? Because if you want to have a true marketplace of ideas, you need to encourage ideas. You need to encourage creativity. You need to encourage art and authorship. And if you don't have that, then people will, if there's no economic incentive to create, you will not have as rich a society. So those 2 things go hand in hand, the right to create and the right to profit from your creation. And that's in large part what today's conversation is all about. I want to introduce someone you all know, those of you who are watching this and our students in her class. Professor Wagner is, I will say that Professor Wagner is one of the preeminent authorities in the world on intellectual property. I had the privilege of having her on my faculty when I was the Dean of the College of Media and Entertainment for 6 lovely years. And I've always treasured her expertise and passion for these subjects. She has had a rich career as an attorney working in intellectual property and copyright, and we are honored to have her on our faculty here at Middle Tennessee State University. Let me present Deborah Wagner.
Thank you so very much. It's hard to call you anything but Dean Paulson, but
I'll take that.
So welcome everyone. And that introduction was a perfect segue, if you will, into our discussion today, because those of you who study with me or have studied with me in the past know that the very first thing you learn is Article someone else want to tell me, but Article 1, Section 8, Clause 8 of the United States Constitution. And I torture most of you into memorizing it so that you are firmly aware of that bedrock core principle that our founders borrowed from the Statute of Anne from England. The one thing we borrowed was the right for our creative artists, creators of aesthetic art, as well as innovation and inventors, to have the exclusive control and ownership of what they create for a limited time. And of course, that's the magic phrase that we've been dealing with over 2 centuries plus. So today's guest speaker is someone who is living in that universe of copyright law and has lived in it for over 2 decades. And so I would like to first give you a sense of who our extraordinary guest is in terms of a bit of information and her background. And then we'll get into our subject matter for today. So Gail Knight Steinbeck, welcome, Gail, is an extraordinarily diverse talent. Now you're going to think she's an attorney, but she's actually not. She's just become one, and almost de facto by virtue of being immersed in fairly complex subject matter and significant litigation for 20 years. But Gail established the Paladin Group, Inc. in 1995 as a loan-out company, and it was created as a development vehicle for production of film projects, primarily for the works of her husband, Thomas Steinbeck, son of John Steinbeck, as well as producing film and television series based upon the works of the estate of John Steinbeck himself. She's had extraordinary success in creating original stories that she sold to Warner Brothers, to Showtime. She has been a first-line editor for many, including all of the works of her husband, Thomas. Something that I found really interesting was in 2000, she did one of her major projects with Arlo Guthrie, and she co-wrote and sold with Arlo a Warner Brothers television series titled The Last Resort. And then 4 years later, they partnered again with a producer to produce a feature film based upon his father, Woody Guthrie's book, Seeds of Man. Tom and Gail created multiple episodic television series, and Gail sold Travels with Charlie as a 4-hour movie of the week to HBO, and Tom adapted that for screen. In 2002, Tom released an extraordinary book. It was actually a collection of short stories, but all quite original. So it was indeed, was it fiction? I think we will discuss that later. It was technically fiction, stories that he
Historical
remembered.
fiction.
Okay, wonderful. And he was published via Irony of Ironies, what is today Penguin Random House. And it was an extraordinary work that received rave critical reviews. Tom published 4 more books, and there are 4 more and a novel to be published posthumously. And we will talk about Tom's passing today in our discussion. At present, Gail is completing the final edits on Tom's memoir entitled Notes from an Ungrateful Child. And then over the years, to wrap up here, Gail and Tom also licensed film rights, which is going to be relevant to our discussion today, to multiple of John Steinbeck's extraordinary works, including East of Eden, The Pearl, and the feature film rights to DreamWorks of The Grapes of Wrath. And these projects were unable to move forward due to litigation and certain matters that we're going to discuss today involved in the estate of John Steinbeck. So Gail, welcome. I'm so
Thank
happy that
you.
you're here.
You make me sound so important.
Well,
there's-
it's the truth, and the truth is power. And so this
Well,
is all true of who you are. So we're thrilled that you're here.
Thank you. It's nice to have a voice for a change, but the truth is there's a difference between me and a lawyer. After taking my first contract law class in college, I decided not to be a lawyer. And
You're probably not
that
alone.
right, lawyers have a degree in the law, and I do not. Let me preface everything I say with I am not a lawyer. And number 2, lawyers, female lawyers, have to wear high heels and fancy suits, and I don't. So,
Well, I've got a story about that for you. I'll tell you another time. But
okay, right.
it was my moot
Right.
court that the judge told me not to wear high heels. But,
Oh, thank goodness.
so, Gail, you have an audience here of, both viewers who have not studied the Steinbeck case, and then those who have in great detail. And so I'm going to suggest that we take this journey today in sort of historical sections to make it more understandable and logical by a timeline of sorts, because there's so much information. And so those general 4 parts are, so I can stay on schedule here, the history and background of the Steinbeck family, John and Thomas and John Ford, et cetera, and Monterey, California, that whole, give us a sense of the legacy of John Steinbeck. And number 2 will be the Penguin years, we will call them, the book rights issues. Number 3, the Los Angeles jury trial film rights years. And then I want to make certain we save time to get a very strong view from you as to the issues of ethics in the courtroom and outside of it via the judicial process and media coverage, and the arguably chilling of your own free speech rights.
Right.
And I will let you explain that issue further in detail. Okay, so let's start with number 1. Can you just tell us about the family, the Steinbeck legacy here?
Yeah, it's interesting. A lot of people have said that John Steinbeck didn't love his sons, he didn't spend time with them. But when you put things in perspective, John Steinbeck was born in 1901. And he was born in the Victorian era. And up until really the late 60s, early 70s, men left all of the child raising to the women. And Tom's mother, his biological mother, was a terrible alcoholic. She was a violent, angry alcoholic. And they lived 4 doors down. After the divorce, they lived 4 doors down from John Steinbeck.
Well,
So
forgive me, which
even
city? Where is this?
in New York, Tom
So
was
he
born
had
in New
left
York.
Northern California and Salinas
He had
and
left
Monterey.
Northern California. So I'm going to give you a little bit of the family dynamics first, and then what happened in Monterey and Salinas. But John was more engaged because there was no maternal dynamic taking place at home.
Hmm.
So after Tom married Elaine, they bought this brownstone. They lived 4 doors down. They spent,
Okay, forgive me. Elaine is which number in terms of wives?
number 3. She's the third and final.
And Tom's mother is which number?
Gwen, number 2.
Okay.
He was much younger than John and had been a big band singer. So he swooped her up into it. So she has copyrights of her own, which is a whole nother story because there's been a lot of theft going on with her copyrights as well. It happens all the time if you're not vigilant and if you don't take care of these copyrights, they will be stolen if they're good. So
John Steinbeck is father. He was more attentive during those New York years.
Yeah, because he had to be, because the boys really didn't have a mother. And when the second son was born, he was 14,
and this is John the fourth.
John 4. He was 14 or 18 months younger than Tom. By the time he was 2, John had met Elaine, the third wife. They were married, and Elaine told me in a cab one day that she had refused to change the diapers for another woman. So Johnny never really had a chance to bond with his dad, and they were not close, but Tom and his father were very close. John was very attentive to him.
Can you speak to Tom's, this is just a moment to set the stage for Tom's nature. Was it similar to his father's as a writer?
Very much so.
And can you describe him?
Tom?
Well, both, if they're similar. What were the qualities they shared?
Well, Tom was a doppelganger for his father. He looked so much like his father. The only real difference between Tom and his father is I think Tom was much better looking, but he had those piercing blue eyes, the same hairline, but he had a wide jaw like his mother. So it framed those beautiful eyes better.
Was there a melancholy to his nature?
Very much so. Yeah, there was a melancholy. He was quite pensive. And at one point, John had written a letter to Elaine. And he said, you know, Tom and Johnny are so different. He said, Tom is a deep thinker and very, very sensitive, but Johnny is the complete opposite. He said, I imagine I will always worry about Tom because he cares so much. And he really was. He was just the most sensitive, generous man I had ever met. Plus, he was whip smart. He had this huge IQ. So
both of them?
Oh, yeah. But Tom, I know what Tom's IQ was. Tom's IQ was identical to Bill Clinton's IQ. And he was just crazy smart. But he was smart when it came to books and learning. He didn't have the social skills, just like his dad. He didn't have the social skills. But when he walked into the room, there was this presence about him that just took over the space. He was so interesting and handsome and funny when he got on stage. I used to say, oh, Tom's over there, he's flapping now. And he would be flapping his wings and telling a big story.
Okay, so Gail, if I may, let's move forward then, because I wanted everyone to understand his nature, because I think that's critical in terms of understanding what you guys then started on a journey to do to terminate the rights of the works of his father. it's critical that people understand the difference between a second generation heir to fame that just wants the money from mother or daddy's achievements, and
Right.
someone like Tom, who lived and breathed the opportunity to further develop his father's work via, I mean, you tell us, before we get into the mechanics of the Penguin case, what was his intent in seeking to terminate the rights of Penguin Books to the works of John Steinbeck?
Well, for years, Tom had been the guy that was out in the field marketing these properties. And Tom drafted screenplays for a number of them. The most brilliant was The Pearl. That's when we met. We met while he was doing The Pearl, and he asked me to take a look at it. We were really good friends for about a year. We became great friends before anything else happened. And I took a look at it. I made a few passes on it. It ended up selling to Disney. In Hollywood, we have a thing called coverage. You know what that means. But the big agencies here would send a screenplay out for coverage to get an idea of whether or not it was marketable, it was filmable, particularly when it came to books, because books are a tough thing to translate. And the coverage on the screenplay for The Pearl came back over and over and over again. This is the most delicious screenplay we've ever read. It is ready to be shot right away. This must be done. That fell apart because of the agents in New York. And
We'll get to that.
we'll get to that later. So, but Tom always had this passion for his father and his father's work. He just adored him, which on this memoir I'm working on, people are saying, you know, it's awfully nice. You got to give us some dirt. But Tom adored his father. There was not that kind of dirt. In 24 years of marriage, I heard him say something negative about his dad twice. And it was always something so minor. I would go, really, Tom? Really, it was
Well,
that
so,
bad for you?
Gail, can you then, because the students understand and know what a Section 304 termination right is. They understand that it's for works prior to January 1, 1978, and they understand that you can get it at the 39-year mark and or the 20-year mark. And so we've wondered as a group, why did Tom not pursue the first bite at the apple, if you will, to get the works back of John Steinbeck in 1994? What happened to prevent that from he and Elaine jointly pursuing the termination?
Right. Well, there were a couple of things that were in play. The most important thing to remember is that you have to have more than 51% of the rights to terminate. And at that point, if things had been normal, Tom would have had 50% and his stepmother would have had the other 50%.
Does normal mean if they got along? Is that part of normal?
No. By 1994, a lot had happened. And what really happened started when the boys got back from Vietnam. They had given their father power of attorney while they were both serving in Vietnam. And they both came back from Vietnam an absolute utter mess. So at that point, they gave Elaine the power of attorney. And what happened then was Elaine, the film studios were sending checks to the agency that were split a third, a third, a third. Johnny, Tom, and Elaine. The publishers were sending checks that were 50% to Elaine, 25% to each of the two boys. So there was confusion. And Tom went to Elaine and said, there seems to be confusion. We need to sort this out. And she said, forget about that. You signed an agreement back when we did the copyright renewals, which was part of the federal statute, and allowed the boys to come in and get certain rights beginning in 1978. It was called the Copyright Renewal Act, and it took place in 1976. 2
Right.
years later, the boys were able to come back in and get their rights. At that point, the publisher convinced Elaine, Tom, and Johnny to give them all their renewal rights back without negotiating a new deal.
Okay, so without getting too mired in that, okay. Two things. I want you to explain the role of the agency in all of this. And
Right.
secondly, then take us to the decision to go ahead and, after Elaine's death in 2013, at least pursue his right of termination for the final 20 years. So agency, and then when he actually did file a 304 notice for the final
Okay.
20.
So there was a tiff. Judge Richard Owen agreed with Elaine and said they signed this agreement. It's too late to come back and change anything. The boys said, we're going to take it to appeal. Rather than take it to appeal, Elaine agreed to split everything a third with the boys on the condition that they give her a power of attorney over the exploitation of all of those rights that she.
What
could
year
be
was
found.
this that you're referring
In
to?
1981 that the case started, but in 1983, the boys signed a settlement agreement with Elaine
Okay.
that gave her power of attorney over the
All right,
rights.
so that is the infamous 1983 agreement.
Settlement agreement, correct.
Okay.
However, moving forward, when Elaine had a stroke her first stroke in 1999, by then Tom and I were married. I called Gene Winnick at McIntosh and Otis, who was the president of the firm, and said,
And they are, McIntosh and Otis is who for this?
McIntosh and Otis is the literary agents.
Give
They're
them
the
a sense of the power of that agency. Who else do they represent?
They represented for a while Harper Lee from To Kill a Mockingbird, Thomas Wolfe, Upton Sinclair Lewis,
Ayn Rand
Ayn Rand. It just
and John Steinbeck.
John Steinbeck. The list was endless, but John Steinbeck, what generated more income for them than any of their other clients.
Wow.
So for the longest time, we were trying to work together, and we did work together. I was doing the film. We were negotiating with McIntosh and Otis. McIntosh and Otis held our hand. We held each other's hands. But when Elaine had her stroke, I called Gene Winnick and I said, look, she's incompetent anymore. She doesn't even remember who Tom is. So we need to go ahead and give Tom back power of attorney so that we can continue doing this business. Gene Winnick held Elaine's power of attorney, and he said, that's a good idea. And because he had power of attorney over Elaine, he had the right to return that power of attorney to Tom, which he did.
Okay, and so just to move forward, but this demonstrates for everyone the incredible power of the agent here for the
Right.
estate of John Steinbeck and the fiduciary duty issue that I know Gail has something to say about later. We'll save that for the end, Gail, but they clearly had great power to decide what happened with the
Correct.
estate, and they received
Correct.
monies first.
Right,
Off the
and
top.
at the time, for years, they were only getting 10% until after all the litigation started, and they tried to get 20% until I went crazy on them, and they settled at 15%.
Wow.
That's
Of every dime that comes to the Steinbeck
every dollar
estate,
that comes to the Steinbeck.
15% off the top.
Right, and yet the contracts that they were taking money off of were negotiated in 1994, so they're sitting fat. They're
Okay,
just
so
sitting there
okay,
collecting
perfect. Thank
money.
you. All right, so the class knows and understands the 1994 agreement. Well, we don't understand it. It's very frustrating, that agreement.
Right.
Most
Right.
notably, the fact that Tom's line is there for a signature and Elaine signs supposedly via her power of attorney. So can you walk us through what happened in 94 between Elaine Steinbeck and Penguin Books, the longtime
Yeah.
publisher of Steinbeck?
In 1994, and I made a note of this because it's important enough that I don't want to mess it up. And it's important for everyone that's listening as they're doing contracts to be very, very careful about how they do this. In the 1994 agreement, what happened, and Tom and I had just been married. We weren't even married yet when this was done. So I didn't know about this until 1996. And what it said in the contract, Elaine created a contract for herself for early works. These were all of the early works, plus 2 works that she had done as memoir type things. And in this contract, there was a clause on page 13 that said, if Elaine Steinbeck exercises her right to terminate grants made to the publisher under section 304C, then certain things have to happen. And it was money that had to be returned, a guaranteed advance that was going to be eliminated. There were a lot of just little things, but it was important to note, because as we get to the litigation part of it, the litigation elements here were part of this discussion before
As
the
to-
second circuit.
Right, did Penguin have a new agreement that canceled and superseded the original publishing agreement in 1938?
Well,
And
not
did she
really.
forfeit, Gail, it's critical not to get everyone too confused about early works and later works, all right? We just need to focus on the 1994 agreement that was the subject of the appeal.
Right.
Okay.
The 1994 agreement said nothing about eliminating the 38 agreement and superseding it.
Right.
Number one. And then number two, it said that if she decided to terminate later, there were certain things that were going to happen. So she signed off on one agreement that we didn't know about it. Then there was another agreement for the works that Tom, Johnny, and Elaine had renewed together. And because she held that power of attorney, in order to, she had to get Tom's agreement to it if it was an actual, factual, real termination, but she did not. Under the statute, she would have to have got his signature, but she did not.
Okay, so let's walk everyone
We
through.
didn't
So
even know about it until later.
Yeah, that's
much later.
okay. So Tom files a notice of termination under 304 to, after Elaine dies in 2003, to then he gave 10 years advance notice so that all the works would have returned to him in 2013.
To him
Right,
and
that
to
would be
his-
the
his
beginning of
niece.
the final 20 years of the life of the copyright.
Right.
So you guys did all the right things. You had high-end counsel. Was Manat involved with you?
Mark Lee from Manat, at the time he was with Manat, Phelps and Phillips, and he's without question one of the smartest IP lawyers on the planet.
Right.
So-
I agree. You will recall I interviewed you and Mark in 2006
Yes,
before the next 15 years of torture. And at that point in time, this was a radio show I had in Los Angeles, guys. And at that point, this estate, it was just a shocker that your book publisher had sued you. Why would they do that? You had put forth the termination, presuming it would go through according to the United States Copyright Act. And instead, Penguin sues Thomas Steinbeck. So
Right.
we need to walk through just Judge Owen's ruling and then get us into the appeal, the
Right.
Second Circuit Court of Appeals.
Right. Well, when after it just happened that the termination window was open for all of these titles in 2003 when Elaine died, and Mark Lee happened to come into the picture on some work I was doing on right of publicity through the Screen Actors Guild at the time. And we met, and he, after a time, he said, well, what are you doing with the Steinbeck estate? And I said, well, nothing. This is all handled by the stepmother. He goes, what's going to happen now? And I said, I don't know. And he said, well, you have the right to terminate these copyrights. And I said, what does that mean? And that's the key, because most people had no idea.
What about
the
Tom?
termination
Did
right
he
is.
know?
Clueless.
Wow.
He was utterly clueless. He had just published his first book, Down to a Soundless Sea. He had just published that. So he was, and most creators are clueless. They have no idea that they have all these rights. So I gave him a list of the titles. He looked them up and he said, you can terminate all the early works and one of the later works that were renewed by the three of them. So we did. And then he started hearing about some of the things that had happened. And he said, that's what they did. Macintosh and Otis, the agents, refused to give us copies of the contracts. And in order to properly terminate, you have to have copies of the contracts. So we ended up having to hire a firm in Washington, D.C. to go to the Copyright Office. At the time, they were called Thompson & Thompson.
Mm-hmm.
We had to hire them to the tune of $8,000 to go through these things.
So you were doing, for students' sake, this is the chain of title. You
Right.
were following, doing your due diligence for chain of title. Okay.
Right. We were looking, and we ended up getting all the copyright reports back. Mark did the legwork and the heavy lifting. And he said, this is a horrible breach of fiduciary duty. If she had your power of attorney and it was returned back to Tom, they've breached their fiduciary duty here. And then we found out that the agents were double dipping commissions on all the stage rights. And we went, we are just so done. Gene Winnick had a stroke. He brought in his son-in-law, who is the guy that got caught trying to steal Harper Lee's copyrights from her.
Okay, so
And everything fell apart.
all right, so this is all agency personnel. So let's move it now from the agency's clear issue.
Know that we fired them because that's where everything happened.
Okay, so when you get into Judge Owen's court, you're the defendants, right? Penguin's suing you.
Right, because what happened next when we tried to fire Macintosh and Otis, Penguin sued us and Macintosh and Otis countersued us. So Macintosh and Otis was both a plaintiff and a defendant. And Penguin, we had called Penguin to say, we're terminating, we want to sit down with you and redo another contract. And they were going, we'll get back to you. Sounds interesting. We'll get back to you. And the next thing we knew, we were blindsided. And we had set aside enough money to deal with Elaine's family and Macintosh and Otis, but we didn't have enough money to also fight off Penguin.
In terms of legal fees, you've had massive legal fees for 2 decades.
That part of the case cost $3 million. And we ended up, we still owe lawyers. It was just horrific.
Okay, so Gail, let's go to then just, can you give us the difference between the lower court Judge Owen's analysis of the facts and what the result was, and then the Court of Appeals flipping on that completely?
Judge Owens was the same judge that had dealt with the 1983 agreement, but Judge Owens wrote opera. So he was well seasoned in copyright law. His wife was a very well-known soprano, and he understood it. He made a couple little boo-boos on the renewed works, but he came in and he explicitly said that we had met all of the obligations required under the Copyright Office. I actually have his opinion here somewhere if you want to go into further detail, and that we were correct. Also, they tried to argue that the power of attorney from 1983 eliminated Tom's rights. And Judge Owens said,
agreement to the contrary.
He said it was an agreement to the contrary, and any attempt to wrest away the statutory rights of these parties is an agreement to the contrary.
So in other words, Judge Owens was consistent with the intent of Congress in passing the law in the first place, to protect statutory heirs and not let
Right.
publishers enter into agreements that would circumvent that intent.
Exactly.
So,
And
this-
he
but
just
Gail, the
got it.
students have studied and read the appeal. And the general question, they'll ask you their questions in a bit here, but I want to get into this case and into the film issue. But what happened in your view for the Court of Appeals to completely flip on the Judge Owens analysis and to decide that the 1994 agreement that Elaine made with Penguin superseded and canceled out the 1938 publishing deal of John Steinbeck, and therefore there was no right to terminate? What happened?
Well, it was interesting because I reread the opinion last night. And I also reread the transcripts. I know all the transcripts. And in the transcripts, the Second Circuit seemed to understand what they were saying. But Richard Deney, who was arguing on behalf of Penguin, unbeknownst to us at the time, had sat on the Copyright Office committee that was drafting this legislation. So he was highly seasoned in what the back and forth between the Copyright Office and Congress was, which is really, really important because it gave him an advantage to understand where the holes in the law were. And he came in and said this. He said, Congress decided that what Elaine did in 1994 with the 1994 agreement was precisely what they had in mind, that she could threaten the use of the termination clause under Section 304C and D in order to get a better deal. And that's what had been argued by Richard Deney. There was a lot of back and forth.
Well, she indeed did that. She did that successfully.
But at the end of the day, the only thing that the court said was that she used it properly by threatening to use a new deal, and that the Penguin 1994 agreement remained in place. They didn't say who got it, because the question was then, well, if she did terminate it, we're fine with that. We're happy to split it a third. But you can't eliminate the rights of the parties identified under the statute in order to get a better deal and to eliminate those rights for
right, which to simplify it, so you can't do a side deal to essentially eclipse the rights of those waiting, the statutory heirs, the children,
right,
as though they don't exist. So there was no regard for what Tom sought to do, and he was not a true signatory to that 94 agreement.
exactly.
Did you know the terms of that agreement? Did
Well,
you
by then
until you saw it?
I didn't see the agreement till 1996. When I heard about it, I said, what's that about? Because what had happened was, I digress. You don't have to know what it happened.
Okay, all right.
But the fact was that I got my hands on the 96 agreement and I went, that's weird. Why is she signing for you? And he goes, oh, well, there's this power of attorney, which is when I discovered all the settlement agreement. It was like peeling back the
yes, it's too complex for almost anyone. Okay,
right.
We're going to leave the Penguin book rights debacle. So you get out of that Court of Appeals, and Tom, I keep feeling such empathy for him. So he's lost the rights to acquire the legacy that he most surely deserved. Right. And would have done great things with it. The Steinbeck Institute you've talked about, the Steinbeck Foundation, all you wanted to do with the Monterey Salinas area for the Steinbeck studies, all of that. So he's lost. So you you petitioned for certiorari to the US Supreme Court at that point, right?
Right. We hired Ted Olson, who was the former Solicitor General of the United States. And he
couldn't get better than that.
Yeah, well, he brought in a young guy named Matt McGill, and Matt was just brilliant. He was a really, really smart guy. And he did all of the legwork, and then Ted Olson was going to do the oral arguments. And something I found out much later, you can't even graduate from law school at UCLA unless you listen to Ted Olson's oral arguments. I mean, he's that brilliant.
No, he's
And we were
extraordinary.
denied
And,
cert.
and so was he able, but you were, what
We were
was
denied. Yeah,
denied certiorari?
we had, according to Matt, we had 3 votes, and Justice Breyer was on the fence because he owned stock in Penguin. So ultimately, he recused
Conflict of
himself.
interest. He
We only had 3
recused
votes.
himself. Yeah.
Right.
So, and this is interesting. I didn't know this, guys, until Gail told me. So how many votes does it require for them to grant certiorari in the US Supreme Court?
4. It takes 4 votes.
So it only
to-
takes
unless-
4 for them to hear the case. And then of course
Right.
it takes 5
Yeah.
to win.
They go into a committee room and they sit down, and their clerks have all read all the briefs. And these kids that are coming in as clerks are whip smart. And they come in and then they argue for a case or against the case to their boss. And then the boss comes in and argues for or against the case to the room. And just a simple side note, when this last appeal to the US Supreme Court, they were getting ready to go into the conference. And 2 weeks before they went into the conference, Justice Ginsburg died. And she had agreed to hear our case not once, but twice, and had wanted to hear it the 3rd time. So we did, again, we only
What
had
a
3
loss.
votes. It was just a horrible loss, not just to us, but it was just a horrible loss to the nation.
To the world. The students
world.
actually know Justice Ginsburg's opinions well. The Atari case is how they cut their teeth on the test for
Really?
originality and copyright. So she wrote that opinion. She was fabulous. So,
Yeah,
okay,
Golden
so
State
Gail,
was one of my favorites, but
let's quickly move into the jury trial film rights issue. If you can just take the students into, you've left the book rights issue, you've lost on appeal. When I say you, I mean Tom,
right.
care of you. And then the certiorari has been denied. So there's a period of time where it's relatively quiet. And then in 2016, activity
No.
picks up with respect to film rights.
It's not really. We still had the McIntosh and Otis case.
Okay, but let's leave them for the moment. We've got to get to the LA jury trial.
So then the LA case came along because Tom had, his power of attorney was returned to him. And we believed that we still had control over the rights that had been previously terminated. So one of the things Elaine did in 1994 and then again in 1998, before she died, she kind of cherry picked the estate, and she terminated some things. She terminated the book Tortilla Flat for film, the film rights for Tortilla Flat, the film rights for The Grapes of Wrath, the film rights for the for something else. I can't remember. But anyway, there's so many. I mean, there are 200 things in print from John Steinbeck. So there's a lot. But anyway, so she had terminated them with Tom. The 2 of them together terminated The Grapes of Wrath. And at the time, we had lost Blake. We couldn't find her. So at the time, it was a 50-50 split, and Tom and Elaine did this together. So what the copyright statute said to us, and actually says, is that when you terminate an agreement, it becomes free and clear, unencumbered of any prior agreements that would have kept you from exploiting the works.
Right.
And
So
in that regard,
forgive me, but this is a moment for the students to digest what you've just said. So in other words, guys, when you recapture the work for your respective artist, then, and I'm having them exploit that work in the good sense of the word with their artist. And so they're free to do whatever they wish. The artist could, do whatever. It's a free and clear, a level playing field for them to essentially start all over with their work.
right, it becomes a brand new copyright.
Yes, and can you deal with the film rights issue right here?
Right.
This is a good moment.
Right. because this was a very big deal. So for years, Tom had wanted Steven Spielberg. Originally, he wanted him to do East of Eden. He had written a letter to Steven Spielberg, and things were kind of quiet. I was continuing to do film deals for the estate. I had The Moon is Down was in prep to be shot in Wales. I was still selling these things, selling these titles. So I had just sold East of Eden again. I had it set up with an Academy Award winning producer, and then The Grapes of Wrath. And The Grapes of Wrath, I read in the trades that they were doing a deal. The estate of Elaine Steinbeck was using for The Grapes of Wrath with Steven Spielberg. So I knew everybody over there. I'd been doing business for a long time.
With Amblin?
With at the time it was DreamWorks, Amblin's new.
Oh, right.
So I called over there and I said, "Hi, Chris, it's Gail Steinbeck." And I said, Tom owns 25% of those rights and his niece Blake owns 25%. He goes, "Oh, I didn't know that." And I said, "Yeah, it was terminated in 1998. And he said, "Can you get me the termination notice?" I said, "Sure." So I sent it over to him. And so he went
Forgive me,
back
but was
to-
that termination notice registered at the United States Copyright Office?
Those were
Okay.
done properly.
Right.
So I sent it over to Chris Floyd, who was the COO now of Amblin, at the time DreamWorks, which is a subsidiary of Amblin now. But anyway.
Okay,
and
forgive me
Chris
at this
sent
moment.
it-
So guys, I mean, this is a critical issue for doing any deal on any film anywhere. They're going to want to know, is the title encumbered in any way, particularly for a remake? You have to be able to deliver proof that the title is free and clear for them to go forward with any film production deal. Gail, just get us to the 2016. Yeah, why are you
Okay,
in
so
a
what
jury
happened
trial?
next was they hired outside counsel. 20th Century Fox owns the foreign rights. Cosmo, leave it. That owns the foreign rights, because in a termination, the termination clause doesn't allow any termination of foreign rights. So 20th Century Fox still owned foreign rights. They had a horse in this race. So 20th Century Fox and DreamWorks hired outside counsel, Lou Petrich, who's one of the most brilliant minds in copyright law and does all the deals for the big studios. Lou Petrich came back and said, "Mrs. Steinbeck is right." So they called me in and said, "Can we have lunch?" As it turned out, Waverly refused this is Elaine Steinbeck's daughter who inherited her estate and had power of attorney over her estate. So she came in and said, "I won't sign this contract if Tom's signature is on it." And DreamWorks knew they needed another signature. So they had me come over. We sat down. We had a lovely lunch out at the studio, and I said, "I don't know what we're going to do here." And at the time, I had a brilliant agent in Hollywood, Bob Bookman. He was at Paradigm and just amazing, one of the true gentlemen of the industry. Anyway, so the three of us went and had lunch together, and I said, "I just don't know what to tell you." So I said, "Why don't you guys think about it and come back to me?" So they came back 2 weeks later and said, "We have an idea. Tell me what you think." How about this? We'll bring Tom in as a producer, which we were going to do anyway.
So Steven
because he
Spielberg is
knows
saying,
this
"I'll
is
bring
true."
Tom in as a producer on the remake of The Grapes of Wrath."
Right. And
Wow.
Tom had been producers before, as have I, on a number of different projects, but they said, "We want his input on this anyway." And I said, "Well, Tom's pretty right now, so I don't know." And I said, "I've been his voice and I'll ask him though." And they said, "Well, why don't we get him to sign a quit claim and we'll let Waverly's team, Macintosh and Otis, negotiate the deal, but we'll have your deal separate so that you don't end up getting the shaft." And
So
I said,
Steven Spielberg is having to get all this done in order to be able to go forward. I mean, this is the hassle of producing a film. You've got to get all of these hurdles leapt over. So let's immediately go to questions.
Are there any completed works of John Steinbeck that still have not been used or even like known about to the general public?
almost everything has been copywritten now that we know of, but not everything has been made into a film. Some of them just aren't filmatic, but the Long Valley, for example, there were 13 short stories in the Long Valley, and those were done by Paramount Pictures for television. There were The Winter of Our Discontent was done. Right now, people are coming and asking about remakes, although nobody's asking for anything at the moment,
Right.
but it's kind of a drag. But there's a lot out there. I always thought that The Short Reign of Pippin the Fourth, do you know that one?
I don't.
It's a comedy. It's the only comedy John Steinbeck ever wrote, and it's hilarious about a guy that finds out that he's in line to be the king of France, and France decides they want to have a king again. And he's
Oh,
like
wow.
on a motorcycle and that kind of stuff. It's really
Okay.
funny.
I'll have to check that out. I actually just got done reading The Moon is Down, which was fantastic.
That's I love The Moon is Down so much. That's one of my absolute favorites, that and Travels with Charlie. I love so much. But pretty much they've all been available. If you're not familiar with Lifeboat, Lifeboat was a screenplay that John Steinbeck wrote. And that one, he tried to get his name removed from it because they made the black guy that was on the lifeboat the bad guy. And he goes, wait a minute, in my story, hero. And he was furious. Of course, it was the days of Jim Crow. But he was furious. He tried to get his name pulled from it. But it's interesting. Some of the old ones are there. And I can't think of anything that hasn't been done except maybe some of very early works as a student.
Maybe
Tortilla
not.
Flat, we supposedly own and control, but who knows at this point.
This case has like some potential to be a game changer for the nation. Like we've seen in previous court cases, usually an appeal means a change to significant law. Do you have any like game plan now that you got denied from the Supreme Court? Do you have a game plan to still like bring this bring justice to this case?
I do. I have been spending a lot of time in Washington, D.C. As a matter of fact, I was there when COVID hit and got trapped on the East Coast for 3 months. But I was working with the Copyright Office and with Congress to get some clarification on the law. I'm still doing that. I started an organization called the Artist Rights Coalition, which the website will be up next week. I just finished cleaning it up and updating it. But what we do is we lobby Congress for changes and clarification of certain cluttered laws. And we also lobby for protection for artists' rights. We file amicus support briefs. We've already filed one in an earlier case. And we work with all the unions. So if you're an artist, my first bit of advice to you would be to join your union. I'm a member of the Writers Guild, the Authors Guild. I was a member of the Writers Union, but I'm doing so much work with the Authors Guild right now that I don't really have time for that. I'm a member of the Screen Actors AFTRA, and there's power in numbers. So if you're working and you are concerned about some of the laws, the best thing you can do is get your groups together. There are a lot of them out there for songwriters. There's the Nashville Songwriters Association, which they do great work. If you're in drama, there's the Dramatists Guild, Photography Guild. They're all over the place, and they have the power. So we work very closely with them now. And there's not a lot I can do for my family anymore. After everything and after the dust started to settle, I realized that it's more important for the message to be out there that you have to be vigilant. You have to protect your rights. You have to join these guilds and unions and be sure that you have all the information you can. I'm surrounded by musicians in my family, and they're constantly coming to me. Will you help me fill out this copyright report? So we're going to go to places like South by Southwest and show people how to do that kind of thing, because that's the most important thing. You cannot protect your interests unless they are filed with the US Copyright Office. And they also just added a new item after the Steinbeck case to their rulings that says In any case in which inaccurate information is alleged, the court shall request the Register of Copyrights to advise the court whether the inaccurate information, if known, would have caused the Register of Copyrights to refuse registration. So that was added after our case. I've spent a lot of time with the Copyright Office trying to get some clarification and requirements that we can get things done. So there's a lot you can do, especially you as a student. You know, students, so that you guys have the power now. It's your world, baby.
Have y'all lobbied for any sort of legislation to kind of make a broader federal contract law? Because I know in your case, copyright law and contract law kind of went up against each other, and contract law is very state-centered, where copyright is a federal law.
We thought we had covered that in the section 304 CD and in 203, because there's a rule of thumb that state law cannot trump copyright law. And there was a clause that addressed that in the Copyright Act. And we thought we had already addressed that, but the Steinbeck case was a real anomaly. People now under section 203 are having the right to terminate without too much trouble. The law was a little bit cluttered. We find some of the older laws are a little more cluttered. I don't know if they're trying to copy British law or whatever, but they're just all words that don't make sense sometimes. And when you have that, when you have these laws that aren't clear and concise, it leaves a gray area that lawyers can argue. And there's not much I can do for the family anymore, other than to try to help others. And that's why we started the organization. I mean, there are a couple of things I could do. We've got a literary agent that, in my personal opinion, is a predator. And there are some things that we can do there, but not much. You just never sign a contract in perpetuity for anything, ever. Please don't do it. And do not assign your power of attorney unless it's perfectly clear that it is not coupled with an interest, because the courts will go crazy using state law, which is exactly what happened here, to try to overrule the federal statute. I wish there were more I could offer you, but there's that. I mean, we think that, you know, everybody thinks that people that hear what happened in our case go, "Are you kidding me? That can't be. You can't do that. You can't overrule a federal statute using a state contract law." But it happened. And once it's on the books, it's there.
So Gail, I was wondering if you might have just a closing thought, something that to leave us with, I guess really about the state of creativity and artist rights, and you know, what you can send the students as a inspiration and sage advice.
For the students of the law, this was a quote I wrote down. I scribbled it down and I've kept it in my drawer, but it was Leon Panetta. If you don't know who Leon Panetta is, you need to look him up. He was a great statesman and just a wonderful, wonderful man. He's from Monterey, California. We know him personally and spent a lot of time. He works vigilantly with a group called Vista at the Panetta Institute to help train young students of the law and politics, and he helps them prepare for a life in the law and life in politics. He's a wonderful man. And he said, and I wrote it down, so I'm going to say it verbatim: "At the end of the day, the lawyer must make the decision. A lawyer who is a master of the law, who loves and understands the machinations of the law. If that's who you are, then you need to learn to write. You need to learn how to tell a really good story. If you're a lawyer who just wants to win, if you just want to win, you better be able to tell a big lie really well." And that's the truth, because right now there is an attack on intellectual property. It started very subtly during the Obama administration when they appointed the people to the Copyright Office that were big tech people. And copyright law has bent in the direction of protecting big tech, in the direction of protecting the big publishers, and is slowly chipping away at the rights of the creator. And if we continue to do that, if we don't stop it and nip it in the bud really fast, we are going to end up living in a very, very beige world without the great music, without the great works. And if you do decide to go into the law, find a hobby, learn to play guitar or something, because we need the arts as much as we need good lawyers out there, because there are a lot of different kinds of lawyers. There are good ones ethically, and then there are bad ones ethically that just want to win. Mr. Panetta was correct. And I can't thank you all enough for letting me have a voice here, and for Emily doing all the work she's done, and you, Deborah. And I'd love to sit in on Ken's talk about First Amendment, because I'm got a little problem with that as well, if you don't mind.
Right.
But why don't we mute me and let me listen to Ken?
And we'll pass it over to you, Ken.
Well, thank you all for being part of this. Thank you, Professor Wagner. Thank you, Ms. Steinbeck. Just a fascinating conversation. I know it enriched the education of every student who's attending this. And we at the Free Speech Center are honored to have this be part of our series of conversations. So thank you all for participating. Keep up the good fight, and everyone be well.